Praveen, as attorneys, we have seen large areas of work previously reserved for the profession being made accessible to others. Will the specific areas of work currently reserved for legal practitioners, such as the rights of appearance in courts and conveyancing work, still be reserved for us in the future? After all, our Fidelity Fund cover protects the public against theft, and the high standards of conveyancing work done by attorneys has contributed to the integrity, security, and sophistication of our land registration system.
Okay, that's a question that has been concerning attorneys and the legal practitioners generally. In terms of the bill, it's Section 35, which says that only legal practitioners who have been admitted and enrolled, those are the ones who can render legal services for reward. So it's very much the current situation where only attorneys, for instance, can do legal work. There was a lot of concern about conveyancers and notaries because the bill in its definitions spoke of conveyancers being any persons who are enrolled as conveyancers, and the same for notaries. But in our discussions with the representatives of the Department of Justice, they've accepted that that should be amended to say that only attorneys or legal practitioners who are admitted as conveyancers can practice as conveyancers.
There is, however, and I have to mention this, that within the attorneys themselves, and here I'm speaking also maybe having my hat as president of the Black Lawyers Association, who are saying that you qualify to do conveyancing work without having been admitted as a conveyancer. But as and when we're negotiating this, we'll see what will be the end result of this. But there's common agreement that you cannot do conveyancing work if you are not an admitted attorney.
What will the requirements be for the admission to the profession for legal practitioners? Will they be the same for attorneys and advocates? And will this allow for easier movement from one branch of the profession to the other?
There's no change. The current position will still prevail. As you know, the current position is that you need a minimum tertiary education of 4-year degree, which is LLB degree, and you need to do vocational training for a period of 6 months if you've not been to the practical legal school. But if you've been to the practical legal school for a period of 6 months, you need to serve articles for a period of 12 months.
What about foreign lawyers? Will the bill allow them to be enrolled to practice in South Africa, or will the current strict requirements where they must have a South African LLB degree and have to be South African citizen or permanent resident still apply? Nano, how do you read the bill on this, or are there other processes influencing this also?
Presently, the bill is silent on that. There's no provision in terms of that. Am I right, Praveen?
All it says is that the council will advise the minister on how foreign qualified lawyers will be, whether they'll be allowed to practice and under what circumstances.
But what I can tell you is that the Law Society of South Africa has got various committees, including the GATS, which is a General Agreement on Trade and Services Committee.
Nano, as an attorney, who will I contact to register my candidate attorney or for questions on day-to-day issues affecting my practice? Or Praveen, if I have ethical questions or I want to ask about rules of conduct or fees that I can charge, do I go to the National Council or the Regional Council?
It has to be regional councils because, I mean, the Legal Practice Council is going to be having a seat at maybe one place, and it's going to be inconvenient for attorneys spread all over South Africa to travel thousands and thousands of kilometers. Just imagine if you have to travel from Cape Town to Johannesburg.
Yeah, and on the question of ethics, I think lawyers would still talk to people at the regional councils in their areas, it's easier for them to do so.
As an attorney, Nano, will I also be paying trust interest to the Fidelity Fund?
The trust interest that is being paid over the Fidelity Fund is utilized in the unfortunate situation where attorneys have misappropriated trust funds. So it is used for reimbursement of misappropriated funds.
Okay, can I just mention something that's been of concern to a number of attorneys relating to payment of trust interest? There is a section in the current bill which says that interest on invested monies, monies that have been invested for the benefit of the client, must be paid over to the Fidelity Fund. And I think one can assure them that that's not going to happen, or rather that not all the interest is going to be paid over. The Fidelity Fund has for some years now been saying that they would like a portion of that interest to be paid over to it, mainly because they provide cover to the people whose monies are held in investment accounts by attorneys, but they get nothing in return. And there'll probably be a small percentage of that interest which will go to the fund, but attorneys should be assured that it's not the intention of the fund or of the Department of Justice to make all that interest over to the fund.
And will I continue to receive free basic cover against theft and negligence from a dedicated indemnity fund set up by the Fidelity Fund, as is currently the case, Praveen?
With regard to negligence, yes, there is provision in the Act, in the bill, to continue with the work of the AIIF, the Attorneys Indemnity Insurance Fund, and they will cover clients in the case of negligence.